Welcome to Devine Intervention, shedding light on Illinois property tax.
Hello, and welcome to Devine Intervention, shedding light on property tax with Nora Devine. I'm your host, Nora Devine. I've been a property tax attorney in private practice since 2005. I've developed a statewide practice in all jurisdictions in Illinois, representing all property classes. Today, we are doing a part 2 of taking a closer look at some recent prosecutions in the property tax assessment space. We have brought back a very popular guest, John Mitchell, to the show. John is an attorney with the law offices of Wilkie Farr, a large New York-based firm. He's in their Chicago office, and he notably achieved an acquittal in one of the defendant's cases, John McLean, who was part of a prosecution that involved a notable property tax attorney on public corruption charges. So he's been following some other notable cases in the property tax space very closely, and we brought him back on to talk about one more case. John, welcome back to the show.
Thanks so much for having me. It's great to be here.
So yeah, getting right into it. The last time we talked about there was a private property tax.
Yeah, the defendant was Nitzega, and it was a case where the Nitzega was a person or defendant who had worked before the assessor's office, and he had played golf with and given free rounds of golf to certain assessor's office employees, and he was indicted for it. And after a trial, again, I told you that my good friend and really talented criminal defense lawyer, Gabrielle Cincinnati, was one of the trial attorneys representing Mr. Nitzega, secured a full acquittal in that case. And we talked about how the Supreme Court's decision in United States versus Snyder, which kind of changed the landscape for federal criminal bribery law, like how it impacted the case.
And what was the other case that you've been watching pretty closely?
You know, there was one where it's someone named Frankie Perez, and Frankie Perez was again another assessor's office employee, and he was indicted by what's called an information, and that was in January of 2025. For those that don't know, people who are charged with crimes can be charged by way of an indictment, which many people have heard of, and that comes by way of an indictment that's returned by a grand jury. People know about that in a general sense. There's another way that you can be indicted in the federal system, and that's by way of an information. And the information is it's a charge by the U.S. attorney, and essentially the defendant needs to sign a form that confirms that he or she agrees to not have the case presented to a grand jury. And what does that mean? Sometimes that is done in an effort to seek mitigation at sentencing by a particular defendant who is not cooperating, but often you will see an information because the defendant is cooperating with the government and therefore waives his or her right to have the case presented to a grand jury because that's part of the person's cooperation.
So if you're reading a news article and they link to a document and it says information by indictment, or if you're flipping through the court's website and you're looking at documents that were filed in a certain case and you come across a document saying information by indictment, you're saying it could mean like two things. Either A, they're not cooperative, or B, they're very cooperative. Is that what you're saying?
That's true. And so what you'll see is like there's either an indictment, and they'll say at the very top, it'll say the special 2025 grand jury charges the following. And so then you know that that's what's represented to, it's an indictment, it's represented to a grand jury. Or you'll see what's called an information, and that'll start out by saying the United States attorney charges as follows. And it says at the top that it's an information. And an information doesn't necessarily mean that a person is cooperating, but in the case of cases involving cooperators, it's frequently used. I worked at the U.S. Attorney's Office for 8 years before joining Wilkie Farr 2 years ago, and often when we had a cooperating defendant, we would charge that person by way of information as opposed to an indictment, and that's what happened in the case of.
So after your 8 years of experience in the federal prosecutor's office, when you yourself see information by indictment on a document, which one of the things do you automatically think is going on?
I suspect often when I see it, I suspect that the person might be cooperating, and you know, you have to kick the tires more, but that is certainly a telltale sign.
Yeah, and then I did glance through the whatever was filed in that case, and there was like a 30-page affidavit or something like that that was not available in the court record. Is that common?
So I have to take a look and see what the caption is next to it. Maybe it just says sealed, but like certain times there'll be an affidavit because the person was the subject of perhaps a search warrant, and maybe it's an affidavit because there's a reason why the government wants to tell something to the judge about the cooperation or something that's just not public and would compromise the investigation, and so therefore it's filed under seal.
But even at the stage when this particular defendant was sentenced, I think he was sentenced to 2 years probation or whatever, what would be the remaining public interest that would be served by keeping that sealed?
That's a great question. And so, often the press will go and file a motion with the judge saying, there's First Amendment reasons why whatever sealed should be unsealed at this time. And perhaps if I had a guess, and this is an educated guess based on my experience, if there was an under sealed document that was filed by the government at the time of sentencing, and in particular, what I know about this Frankie Perez case, which is that at the time of sentencing, the prosecutor said orally that the defendant, Frankie Perez, he cooperated and his cooperation was significant, but it did not lead to charges against other people based on both legal and factual problems that were unforeseeable and were not the fault of Frankie Perez. And so what I suspect is that sealed document laid out the different types of things that he did as part of his cooperation that didn't end up leading to indictment of other folks. And unsealing that document would presumably detail the people against whom he cooperated who weren't charged with a crime. So that would be terribly prejudicial to those people who were suspected of committing a crime, but the government didn't have enough evidence to charge them with a crime. And so leaving that document sealed seems the prudent way to go about it under those circumstances. Although, of course, you and I would like to read them.
Well, that's probably good lawyering, right? It probably cost quite a bit of money in legal fees to make sure that information didn't become public.
Yeah, and I think a lot of times the government will take that stance, even in the absence of good lawyering, in the sense that including information about people who were under investigation but weren't ultimately indicted, that can ruin people's lives, right? And so, sure, the details were probably kept under seal at the request of the defense attorney, but that the government honored that request in large part because if they didn't do so, it could really add reputational harm to people who weren't ultimately charged with a crime. So it really does seem like.
What were the highlights of what he was accused of?
So what Frankie Perez was an employee of the assessor's office, and according to the indictment and publicly available information, he was a supervisor there, and so he had dealings, and the people he supervised had dealings with law firms that had business in front of the assessor's office, and the allegation was that he had received gifts and other things of value that exceeded the threshold, and that in doing so violated the federal bribery laws.
And it was like sporting events and like dinners and so forth, right?
Exactly.
But I mean, I think that it totaled up to quite a lot of money. I mean, they were saying on the high end, it could have been something like $1.5 million or something. It was some extreme number.
Yeah, you know what? I hadn't seen that the total dollar amount that he had received. It might have been in the plea agreement that he entered into with the government. But I will tell you this: that the dollar amounts can be insignificant, and the federal government, particularly in Chicago, but all around the country, they will be really interested in the case. And the reason they are, Nora, is because in the view of the U.S. Attorney's Office, going after even small bribes or gifts that went to a public official that corrupted the process, they view that as extremely serious, and they view it as a really, they call it general deterrence. And by bringing that case and saying, hey, we will even bring cases involving a round of golf or involving a dinner that will cost $150. There's no, because of the impact that can have on current assessor's office employees who they hope will see that and say, we're not even getting close to the line. And so that's what's going through the federal government's mind.
So this is like the proverbial spike with the head on it or whatever, right?
That's true. That was the original general deterrence, and now the current version of general deterrence is, and make them very public. Make it very public that they brought the case because they want to send a message that even small acts of what they view as corruption are going to be prosecuted. And so it's a way of dissuading people and discouraging them from getting close to the line.
So if you yourself were still in the prosecutor's office and you yourself were in charge of pursuing public corruption in Illinois, like how would you pivot in this new environment? Like what would you be looking toward now?
I think the reason why several of these cases have not gone as well for the federal government is I believe because of the investigation was conducted with an understanding of the law as it existed at that time, and then the intervening event was this United States versus Snyder case, and then they had to try the case based on evidence that was gathered under the old legal rubric. So now, if you are investigating public corruption offenses, you have right in front of mind this United States versus Snyder case, and so you are looking really hard at whether something is a gratuity versus a bribe, and you're making sure that you gather evidence that allows you to prove beyond a reasonable doubt that there was a quid pro quo exchange between the bribe payer and the public official. And so what I would be doing is a lot of the same things that you've done that the federal prosecutors have done historically. It's just that you would have that laser focus because that's the law. And so, you can't really blame them for bringing a case under one legal rubric that changes and then having to try it based on evidence that was gathered with your understanding of the laws that existed before that United States Supreme Court.
It just sounds like what they need is so explicit, and people don't really talk like that. It's almost like you have to be, like somebody took me to lunch one time, and I'm pretty sure this guy was wearing a wire. He must have been, because he was saying the craziest things to me. And, he was like a legitimate property owner. So I was like, oh, sure, I'll take him to lunch. Maybe he'll hire me, And at this lunch, he was saying to me, he's like, look, I've got this huge building in the Loop, but it could qualify for this other, special treatment, which really would have been enormously lucrative for me if I were to get this case. So, obviously nobody's trying to, catch somebody up with a small case. No, it's a big case. It's a lucrative case. It sounds like a sure thing, right? And he's like, and I said, well, yeah, it's tough. Like those are tough cases because those are like, they don't love to give residential treatment to buildings that are mostly commercial, and you need your own entrance. And I was kind of telling him about it. And he goes, look, I just need to know who can I just pay off so that I can get this done. And I was like, look, man, I don't know what kind of movies you've been watching, but like, this is not how any of this is going. I've been in this business for 15 years and there's nobody that you're going to like go hand money to and make this happen. Well, I just need to know which of the firms are like paying off the guy that does the certificates of error. And at this point I'm thinking, okay, this guy's wearing a wire, like this is, this guy's clearly wearing a wire. So I go back to the office and tell a colleague, or, I said, I had this weird lunch. This guy was saying these weird things. I told him that's just not how people talk. So I don't know how many other firms, if anybody's listening to this and want to tell me if this guy also had lunch with you and said the same things, because I thought it was the oddest thing. But I guess they really do need you to say something that explicit. But that's just, first of all, it's not being done that I know of. And second of all, even if it was being done, they wouldn't be talking about it like that, So I don't know how they're going to, how do you build those cases?
The one way, you're absolutely right. I mean, it's very rare for someone to say, I want to pay you a bribe in exchange for, or I want to give you a duffel bag full of cash in exchange for you going to vote this way tomorrow. And so that's the very rare case where there's someone who's that thick that would talk that explicitly. However, it happens. You won't be shocked to know. I mean, you actually had that occasion in that example you just gave. But really, what you're looking at in cases, whether they're brought now, whether they're brought 5 years ago, whether it's public corruption, whether it's fraud, it's really the whole all of the facts and circumstances. And so, like, the kinds of things that you would see in a case would be, for example, attempts to try and keep from public view your actions. So if you were to give tickets to a game, perhaps you would leave the tickets in the name of someone other than the recipient at the front gate of at the United Center. Do different things to, you would say, hey, I'm not going to be able to give them to you directly. I'm going to have someone else bring the tickets to you. Doing things like that to kind of give the view, like, well, why, if you thought what you were doing was okay, then why are you taking all these steps to conceal it? Paying through a cashier's check in the name of an LLC, as opposed to just giving the person a personal check or the like. Just doing, these are not the best examples, but that's the idea. The idea is attempts to conceal are really good windows into what's in the person's head. And that shows that the person believes and knows that they're doing something wrong. And that's really powerful evidence, almost as powerful as a thick defendant who says, on recording, here's a duffel bag full of cash. Go.
Well, we did have a case like that, and I don't know if I told you about it, but we did have someone a few years ago. It wasn't even 5 years ago, I don't think, but it was an employee at the Board of Review who had power over the actual keystroke process, or had power over the person that was in charge of the keystroke process. So there's a process where they agree that the assessment's going to be reduced, but that agreement has to be signed off on by one employee of each of the 3 commissioners' staffs. So they have checks and balances on whether or not there's going to be an above board reduction. But then that flow then goes to a person who's actually sitting in front of a keyboard and in charge of, like, pushing in the actual numbers on the keyboard. Now, this person is the fulcrum, right? They're the bottleneck. They actually have power over, like, what that number is going to be.
Right.
So this person needs to be accurate, and putting checks and balances on this person is a little different than putting the checks and balances in place over whether or not conceptually a reduction is warranted or not. So in this case, somebody came in with a bag of cash, and I teach an ethics class for assessing officials, and I always tell them, I said, guys, if somebody's bringing you an actual bag of actual cash, they're wearing a wire. Like, this is not behavior of a normal person, And sure enough, this person not just had a wire, but they had a video camera on. And so they did arrest and indict and I think convict somebody who was a lower level employee at the Board of Review. And it's just such a headache for the public official himself, who's a reputable guy and wouldn't be taking any bags of cash from anybody. But yet, you've got 120 employees in that office, and even more in the assessor's office, and people don't realize why there's so much corruption in the assessing world. But it's because it's one keystroke error or one keystroke difference can make a massive difference in the amount of property tax that somebody has to pay. So we did see a bag of cash case, like, recently in Cook County.
Yeah, and I would say that if either the person who has the bag of cash, they're either wearing a wire, as you said, which is the most likely scenario, or it's inevitable that they're going to get caught, and then they're going to, as part of their cooperation, their inevitable cooperation, they're going to relate the instance when they paid a bag of cash to that person. So for so many reasons, it's a terrible idea.
It's not a valid way to enhance your salary that year. Let's just say that. And the problem with that is, like, if people hear you do that, then guess what? Now you get all these other people, like, wanting the same thing. And it's not universalizable. It's a total disaster from an ethical standpoint. And you just can't even start with small things, because the smaller things lead to bigger things. And it's not worth it. And so, yeah. And we teach also that and we don't just teach it, but the CIAO Code of Conduct, that stands for Certified Illinois Assessing Officer. They have a code of conduct, and it says, hey guys, we're not just trying to avoid actual impropriety. We're trying to avoid the mere appearance of impropriety. And I think the International Association of Assessing Officers has a similar provision in their code of conduct. So, so then you get into not just, what does the county gift ban ordinance say? What does the state gift ban ordinance say? You get into, do you need a credential to have your job? Is that credential coming from the IPAI? Is that credential coming from the IAAO? If so, what does their code of conduct say? Do you need to go get convicted of something like this in order to lose your credential, or do you need to be worried about even the mere appearance of impropriety? So several of the instructors who teach that class don't even take a paper clip or a cup of water from somebody who has, business before your office. It's just not worth it. What other advice would you add?
I think that's totally true. And I can't emphasize enough. We've talked about previously, the idea that, there's one thing about, hey, if you are charged with a federal crime and you're facing the potential of having to go to prison if you were convicted, that is one analysis that we talk about. Like, hey, there's certainly is a high bar for the government to prove beyond a reasonable doubt that there was a quid pro quo. But if you've gotten to that point, you've already lost. Like, if you have been indicted, then you have already lost big time. And we talked about you've lost in the sense that you are the reputational harm, stress, the personal stress that you're going to feel, your family members, you're going to have a hard time finding a job just by getting indicted. And then there's the money. You have to pay a lawyer like me to represent you, and that can add up quickly, hundreds of thousands of dollars, in excess of $1 million if you're going to go to trial. But then there's also the state and local laws like we talked about, and violating those can end up getting you fired from your job and the like. And so it's just not worth it. Don't even get close to the line.
Although I did read in one of the articles that one of these property tax attorneys who was under indictment was able to use his funds in his campaign fund to pay his illegal bills, which were in the millions. So I guess that's one thing. If you're really good at fundraising, you could use that war chest to, pay John Mitchell's very reasonable legal fees, which
that's in the list of things that make the average Cook County or Illinois resident frustrated. It's very common for folks who are under investigation or have been indicted to use campaign funds to pay for their legal costs. It's been happening for many years, and I'm sure it'll happen in the future as well.
Well, we aren't going to solve these problems today, but thank you so much for joining us again, John. It's always great to hear from you, and you just have the greatest take on these cases. And hopefully we won't have to do any more of these between now and the end of the year, but you never know. But to all the listeners, thanks again for joining us on Devine Intervention, shedding light on Illinois property tax. If you ever need legal opinions about good and bad behavior and what's right and what's wrong and what laws might apply to you, John Mitchell's available. He's at Wilkie Farr. He's in their Chicago office. And if you ever need help with your property tax issues, you can always reach out to my office. Our website is www.thedivinelawgroup.com. And I hope you liked today's episode. If so, please like and subscribe. And John, thank you so much for coming on the show. It's always great to see you.
Yeah, it was really fun. Thank you for having me. Appreciate it.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.